This hearing is in the matter CFI 83 of 2018 before Justice Roger Giles and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Mr. Michael John Wheater. The defendant is represented by Salem Dwela as a litigant in person.
That may not be entirely right. Mr. Walid Dwela, you're the claimant, I think, are you not?
Correct, yes.
Yes.
Hello, Mr. Judge.
Yes, and Mr. Wheater, you're for Damac.
That's right, my lord.
Just so we know where we are. All right, then, thank you. Well, now, the purpose of this really is to get this case sorted and get it to a hearing, isn't it? So the dispute can be resolved. The starting point would seem to be to get the points of claim into shape. Mr. Dwela, a direction was given that if you were going to amend, that a draft should be provided by Monday. That doesn't seem to have happened.
I've submitted the memo submission, the list of issues. In terms of the points of the claim and the particulars of the claim, I believe this, I proposed, a date of the 6th of May on my, just give me 1 sec. Let me just, in the case management order, I proposed the date of the 6th of May for the amended particulars of the claim.
Yes, but were you told that I had directed that if you were going to amend, then a draft should be provided by last Monday?
I was not aware of that. I was not aware of that. The documents that I'll be honest with you. I was not aware that this needed to be done for the CMC.
Well, were you
my lord?
Just a minute, Mr. Wheater. Were you told of it, though, please, Mr. Dwela? I would like to just get to the bottom of this, and then we can move on. Were you told of that direction?
No, not that the particulars of the claim needed to be amended by today. No.
That's not what I actually asked. Yes, Mr. Wheater, what did you want to say?
The only thing I wanted to say, my lord, is I've just checked with those instructing me, and we were not aware of any direction to that effect either.
All right. Well, something may have gone wrong. I asked the registry to give that direction. Thank you for that intervention. All right. Well, then, Mr. Dwela, in your memorandum, you indicate that you propose to amend also to include an allegation of fraud. Is that correct?
If we are able to do that by your justice, then I will do that, because my understanding was that the case of fraud, because the way that like our previous lawyers actually framed the particulars of the claim is that they did not include the case of fraud. I was not involved at the time by my dad, so it was my dad following the whole thing with his previous lawyers. So because we failed to do that within a certain deadline, and just the case of misrepresentation and breach of contract were brought forward, then we would not be able to bring the case of fraud. But if your justice will give us the permission to amend the particulars of the claim to include fraudulent misrepresentation, then we would do so.
Well, I don't know your case, but your lawyers may have refrained from including fraud for good reason, because there's a very strong ethical restriction amongst lawyers against pleading fraud unless you have really good reason to allege it, for the obvious reason that it's a very serious allegation. So I think if you are contemplating doing that, as often litigants in person do, or people who aren't legally qualified when they don't realise the significance of it. You need to think very, very carefully about that. May I ask, are you legally qualified, Mr. Dwela?
No, not at all.
All right. Now, is there the road that you're embarking on is not an easy one. You would be much better off if you did have legal representation. I won't say any more about that, but you really should seriously consider that, because otherwise you may end up selling yourself short.
Your Justice, in the past, we took different lawyers. Unfortunately, the expenses of legal representation in this country, are very expensive. I mean, the amount that we have been quoted as well by lawyers would be the same amount of the value of the unit that we're actually in dispute for. So I will seek consultation, of course, but in terms of seeking legal representation, we've gone through that path and we've changed lawyers 4 or 5 times. We have exhausted, our financial means to go forward with that route. So
I can't make you do it, and you're
sure.
entitled to litigate, or your father is entitled to litigate without a lawyer, but experience indicates that it's sometimes short-sighted. However, as I said, I will say no more. Mr. Wheater, what do you say about amendment possibly to include fraud? It seems some amendment definitely is necessary to make out to better frame the representation case.
My lord, I think that has to be right. The particulars of claim concentrated on breach of contract, and that was certainly the focus of Mr. Dwela's attention, both at first instance and in the Court of Appeal. There was no previously pleaded claim in relation to fraudulent misrepresentation, and I would simply point out that at paragraph 9 of the judgment of the Court of Appeal, and my lord, if you have the CMC bundle, you'll find that at page 77.
Yeah, paragraph 9.
Paragraph 9 opens with the words, "The judge correctly concluded that no claim for fraudulent misrepresentation had been pleaded, and it was now too late to do so."
Yeah. Well, it may not be too late if an amendment is possible now.
But my lord, in principle, we agree that the claim in relation to misrepresentation should be amended. If Mr. Dwela's claim is in time to bring a claim for fraudulent misrepresentation, we'll have to. It's not ideal that we don't have an amendment before us today that we can consider, but we'll have to consider any proposed amendment as and when it is produced.
Yes. Well, I think we might let it happen. Your proposed case management order provides for amendment within a certain time, and at the moment we will say that it may include fraud as well as ordinary, if I might call it that, representation. But Mr. Dwela, please do consult, if you can, about whether it's really correct to include fraud in any amendment. So we move then to the next thing.
My lord, before we move on, I apologise. Before we move on, just in relation to the scope of any amendment, obviously, my lord will have seen from the list of issues proposed by the defendant that he still proposes to advance his claim for breach of contract. Now, my lord, we say that the decision of the Court of First Instance struck out the claim for breach of contract, and the decision of the Court of Appeal merely held that Mr. Dwela had an arguable claim for misrepresentation that hadn't been considered in that first instance decision striking out the claim. So, my lord, we would seek a clarification to the order saying that he's permitted to advance his claim in relation to misrepresentation, but any claims for breach of contract remain struck out. And I can take my lord through the relevant sections of the judgments if that would assist.
No, there is no need. That is certainly what I understand to be the position, and I thought that Mr. Dweller's occasional references to breach of contract were just simply an aside that didn't mean anything. Mr. Dweller, that is correct. Your claim is limited to misrepresentation, possibly fraudulent, depending. Do you understand that?
Yes.
Breach of
Yes.
contract is out of the picture.
Understood.
Okay. Then Damac wants to bring a counterclaim. What's the nature of the counterclaim, Mr. Wheater?
My lord, the nature of the counterclaim is for service charges. It's Damac's case that there was no misrepresentation, the underlying sale and purchase agreement has not been rescinded, and that the claimant remains bound by his agreement. Pursuant to that agreement, the claimant was obliged to pay service charges in respect of the unit. The current service charge account runs to some 298,000 dirham at the moment. And my lord, this is a minor amendment. If I could take you to page 23 of the case management bundle,
Well,
you'll see that
don't worry. We're just looking at principle. But what happened about title to the unit, Mr. Wheaton?
I'm sorry, my lord, I didn't quite catch that.
What has happened about title to the unit?
Title to the unit, as I understand it, remains with Mr. Dwela. The unit has not been recovered or repossessed. It's still his unit, for which he still pays or should be paying the service charge. So
title was transferred in whatever the appropriate way was it? There are inconsistent references in the papers that I have seen.
My lord, my understanding is it was, but I'm just taking instructions, so I may be able to come back to you on that.
All right. Well, Mr. Dwela, in principle, it seems fair that and correct that Damac should be entitled to claim those charges. If you are successful in your father's case, then that will fall away because you won't have been liable for them. But on the other hand, if you're unsuccessful, then at first blush, there's a good case for saying that your father would have to pay those charges. So it seems reasonable that counterclaim should be permitted. What do you want to say about that?
Your Justice, we have never signed the transferal of the property because we're not technically the owner of the unit up until this point. As we're all aware here that the total area of the unit that was, according to the SPA, was meant to be 2,402 square foot, but what we did receive was almost 48% less. We've never signed the handover, despite the several solicitations from Damac that attempted us to sign the handover even before we viewed the property. And they wouldn't let us view the property until we would sign the handover, but we didn't. And after many solicitations, then they allowed us to get inside the property. And when we discovered that the size of the property was almost half of what was we agreed on the SPA, then we decided not to sign the handover. And then when we started negotiations and we started calls and we started emails, that led, unfortunately, to us, raising this legal case.
Well, Mr. Wheater, that does seem to throw up the question of whether there has been a transfer of title.
My lord, it does, and I'm still taking instructions on that. I know there have been some issues as to whether or not Mr. Dweller refused to take the unit. There may be issues of specific performance in relation to the SPA if it wasn't procured by misrepresentation, because Mr. Dweller would be obliged to purchase the unit, and we would be, in one view, my lord, prevented from selling it on. So, my lord, I would still seek permission to bring the counterclaim, subject to our further investigations in relation to title.
Well, if your further investigations indicate that title has not been transferred, I would expect your counterclaim to be a claim for specific performance.
Indeed, my lord.
which is the reverse, as it were, of Mr. Dwela's claim.
Indeed.
Mr. Dwela, do you understand that if in fact title has not been transferred, but if you are unsuccessful in your father's claim, then that would seem to mean that your father would have to take title?
I understand, Mr. Justice. I do understand, yes. So my understanding here is that obviously, if at the end of the course of this case we would lose the case, we would have to pay for the service charges,
Right.
which makes sense.
What I think then should happen is that there should be the ability for Damac to bring a counterclaim, but that the counterclaim should include specific performance, that is, requiring your father to take title, which is, as it were, the reverse of what you're asking for, and that will mean that both sides of the dispute can be given effect, so to speak, depending who wins. Do you follow that?
Not entirely, no.
I think it is right that the counterclaim, if Mr. Wheater's instructions require it, should be not just to claim the amount of money that he mentioned, the service charges, but also, if his instructions require it, it should include claiming specific performance against your father. That would mean that if you lost, he would win on that point. At least that's the way it would seem to be. Okay,
Understood. Yeah.
So we'll let that happen as well. That can be the counterclaim. Well then, Mr. Dwela, you've seen that Damac's proposed case management order that sets out quite a moderately lengthy timetable. That might be a convenient way to proceed further now. Have you got any particular comments about that proposed timetable? Do you know the one I mean? Headed Defendant's Proposed Case Management Order of Justice Roger Giles. Have you seen that?
I might have missed that.
Yeah, that's really most unfortunate. Whereabouts in the bundle is it, please, Mr. Wheater? I have a hard copy.
The defendant's case management order is at page 61 of the CMC bundle, or page 88 if we're looking at the master bundle.
Right. Mr. Dwela, have you the opportunity to turn that up now?
Yes, just give me 1 second. This is of the consolidated bundle, yeah? Which page again?
Mr. Dwela, if you're in the master bundle with all the documents in, it's on page 88. If you're in the CMC bundle, it's page 61.
Okay.
My lord, whilst Mr. Dwela is checking that, can I just check whether or not you received a skeleton argument from me? Because there is that is unfortunate, because there was a directions proposal from Mr. Dwela, which for some reason has not made it into the bundle, and in my skeleton I set out side by side the proposed dates.
I see. I don't have that. Was that filed?
It was, my lord.
Alia, can you find that and perhaps send it to me?
Yes, Judge.
excuse me, I'm looking at the master bundle. There's only 80 documents, correct? So did you say 88?
In the master bundle has over 100 pages, over 150 pages, and it is page 88. If you're in the case management bundle, it is page 61.
Okay. Let me see if I can. Okay, yes, I am there.
All right. So that's a document that the main title is Defendant's Proposed Case Management Order of Justice Roger Giles QC. Is that the one you have?
Correct, yeah.
It starts upon reviewing the court file, upon reading the case management bundle, and so on.
I'm there.
Okay. Well, let's use that as the starting point. The first thing is dealing with your amended points of claim, the 6th of May, and I think that was the date that you had in mind also. And then there's the reference to the counterclaim, and we've discussed both of those. 27th of May is the time for that. Do you see paragraph 4? That's simply a formality that means that you don't have to show a marked up copy, but because we're really going to be starting afresh, as it were, we can just start with fresh documents. Are you with me so far? Are you there, Mr. Dwela?
Yes, yes, yes.
Okay.
So yeah, that's yeah.
Paragraph 5 then is the time for you to serve any reply, and I think in that there should be inserted after the word reply and a defence to counterclaim. I think that should be there, shouldn't it, Mr. Witter?
It should, my lord.
Yep. So that means that you need to do that by the 10th of June, Mr. Dwella. All right, yeah. So far? Just give me a moment while I check to see whether that document has come through. All right. I now have that document that Mr. Wito referred to, which has the various different dates set out in a very useful table.
My Lord, would it be helpful for me just to highlight for you the two main areas where the timetables diverge?
Yes, that would be useful, thank you.
My Lord, the first is you'll see that the parties were agreed about the first stages of pleadings, but we had included in our proposed directions that Mr. Dwela should have the right to put in a reply, whereas that doesn't appear in Mr. Dwela's proposed directions. So that's the first divergence, is to give Mr. Dwela the time to put in a reply.
Well, he certainly should have that time, because there must also be a defence to the counterclaim.
My Lord, indeed. So that's the first divergence in the timetable. The parties are largely agreed as to the periods of time necessary for instance, Part 19 requests, lists of issues, and production of documents. The next divergence is in the time for compliance with any disclosure order. Mr. Dwela's proposals were that all the parties should comply with disclosure orders and requests for disclosure within 7 days. Whereas, my Lord, our proposal is it should be 21 days, particularly given that this is a transaction that is some 10 years old. And if we're going to be searching for documents in response to disclosure requests or pursuant to any order of the court, we might need rather longer than 7 days to do it. That said, we do think we can achieve 21 days for disclosure, and then thereafter, the difference is really in the time it's going to take to put witness statements together. Mr. Dwela says witness statements should be 2 weeks after disclosure. We say it should be 3, and he says witness statements in reply should be 1 week, and we say it should be 2. And my Lord, we say that being a misrepresentation case, this is going to be quite a fact-heavy case, and the witness statements will be important. So we say in the circumstances that timetable is justified. And as my Lord has only just seen my skeleton, there's one other issue that I would raise, and that is in relation to the question of experts, which at the moment neither side proposes that this case requires experts. There is a dispute between the parties potentially as to the actual size of this unit. Whether or not that remains a live issue following the close of pleadings is difficult to say, because the parties at the moment, I think, are speaking at cross purposes, because there is a dispute about the total unit size or the total unit area. And the claimant says that the total unit area is less than that which he was promised. Well, the defendant accepts that, but says there is a specific mechanism in the contract for dealing with changes in the unit size during development. And the claimant also says that the square footage floor area of the unit itself is not what he expected. Whereas the defendant says that properly construed, the contract makes clear, the SPA makes clear, that the total unit area includes both the unit itself and an element of the common parts that goes with the offices. So there is an extent to which some of the total unit area is out with the four corners of the demise of the unit itself. So, my Lord, in a nutshell, we don't know whether and to what extent the unit area will remain in dispute following the close of pleadings. But at the moment, we have not included any direction for expert evidence. The claimant purports to have a report from Cavendish Maxwell in relation to the size of the unit. We haven't seen that, but we don't know at this stage whether or not any expert evidence will be required. So, my Lord, one of the things that I put a pin in my skeleton argument was whether the court would give directions to trial today or give directions up to the close of witness evidence with a review CMC to determine whether or not there is a requirement for expert evidence and give consequential directions for that expert evidence and trial, or whether or not there should be directions through to trial today with potentially an earlier review date to see whether or not expert evidence was going to be necessary. Because we say that's not a a decision that the court can take, and certainly not a topic that we are able to cover with any clarity until the pleadings are closed.
Yes. Well, thank you for highlighting that. My immediate reaction to it is that the question of the area of the unit, which is just a matter of measurement, is not a matter of expert evidence. That is something which will form part of the what we might call the ordinary evidence. A witness may say that that witness took a tape measure and measured, or in whatever way that person measured, but that is just a question of fact, not a matter of expert evidence, and my reaction is that that is to be included in the ordinary exchange of witness statements. Mr. Dwela, do you understand that, and do you have any comment on that? Any objection to that course?
Your Justice, back in 2019, our previous lawyers contacted Damac asking to get like an independent surveyor, and we both parties agreed on getting an independent surveyor, Cavendish Maxwell, to actually measure the unit. That was after several negotiations. Now, when Mr. Michael Wheater says that they have never seen that report, I'm afraid that is not correct. We have shared that.
He did not say that, and that is irrelevant. Let us concentrate on any question of what is the area is just a matter of evidence which will be included in witness statements in the ordinary exchange of witness statements.
Correct. Yes. So we wish to include that in our evidence, because that is a matter of fact. It's the surveyor was an independent surveyor that was agreed with the MAC. They measured the unit, and they found out the conclusion was that the unit was almost 48% less than what was expected.
That's a matter for you. If that's how you propose to address the question of area, then that's a matter for you. But it's not there's not going to be any question of expert evidence in this case. No separate regime for expert evidence.
Okay, thank you.
If we go back, thank you for that explanation of the timetable, Mr. Wheater. Mr. Dwela, I've had the opportunity to see the differences. My feeling is that the times that Damac has suggested are more realistic. Production of documents in a case such as this is not a 7-day exercise, and I think it would be foolish to say that it was. Likewise, it seems to me that in your own interests, to have more than 2 weeks for witness statements or 1 week for statements in reply would be a good idea, because, as I said earlier, the road you're embarking on is not an easy one, and I think, again, it would be foolish to put you under the pressure of the 2 weeks just for the sake of an understandable desire to have the hearing a month or so, possibly earlier. So my feeling is that the times in the document that we recently found, that's the defendant's proposed order, are reasonable times. Now, I'm open to be persuaded otherwise, and if you have particularly good reasons for saying that the times in that are not appropriate, but that's my starting point. What would you like to say?
Yeah, Your Justice, I'm open to the suggestions.
Thank you.
So, yeah.
Now, Mr. Wheater did indicate whether we should prepare the case up to a certain point and then take stock before appointing a hearing date. I think in this case, particularly because it's so old, we should appoint a hearing date now. And that way we will all, meaning you, I suppose, rather than me, be under the pressure of having to meet the timetable so that that date can be held, because that will be important, and I think it should be understood that if we embark on this timetable with a hearing date at the end of it, any divergence, any slackness on either side that means that there's some problem with reaching that hearing date will not be well received at all. I'm sure that is well understood. So that really takes us, I think, up in the document that we have, if you still have that before you, Mr. Dwela, to the progress monitoring date, which is proposed as the 14th of October. The document leaves the time open, but I see no reason why it shouldn't be 10 a.m. if we work by Dubai time, as we are now. Then if we look at to try and find an actual trial date thereafter, we have this problem that I in fact have October, or the latter part of October, the last bit of October and most of November are in fact out for me. I have other cases being heard. I was going to propose to the parties that we make the trial date the 1st and 2nd of December. Again, I think the estimate of 2 days looks about right. That would, if I can put it this way, allow a little bit of time in case there's some slippage in the timetable also. Mr. Wheater, from your point of view, would the 1st and 2nd of December be okay?
My Lord, may I just take instructions on those dates from my from those who instruct me? From my point of view, I think that would be fine, but I'm just taking instructions.
Please do. Mr. Dwela, again, would that be okay from your point of view and your father's, of course, as he would be a necessary, I assume he will be a necessary witness.
Your Justice, I mean, if obviously if that is more convenient to all the parties, including yourself, then we will accept.
Okay. Well, we'll just wait and make sure that it's okay with Mr. Wheater, and then we can fill in some of the dates that.
My Lord, it is.
Then, all right. So then, if we take the document, then the paragraph 24 will be completed, listed at 10 a.m. on the 1st of December with an estimated duration of 2 days. That's Mr. Wheater's estimate. As I said, it seems about right to me for a case like this. Mr. Dwela, are you in a position to say otherwise or not?
No.
No, thank you. Then if we work backwards, I suggest that the date in paragraph 23 should be the 28th of November. We'll look at all these together. The dates in paragraph 22 should be the first one, the 28th of November, and the second one, the 29th of November. And then the date in paragraph 21 should be the 28th of November. So the 28th of November is the time for getting most of the pre-trial documents organised, and but 1 day later we have to get the defendant's skeleton argument. Any comments on that as a proposal?
No, my Lord.
All right. And then I think the only other date would be the agreed trial bundle. And I don't see why we shouldn't just say no later than 2 weeks before trial, full stop, and delete the words in any event no later than 4 p.m. on X date. Any comments on that?
No objections from my side.
Thank you. All right. Well, that I think gives us then a complete timetable up to a trial on those first 2 days in December.
Sorry to interrupt, but
Yeah.
the 2nd of December will be a public holiday in the UAE because it's the National Day.
Oh dear. Thank you very much. Okay. Well, I guess we could make it the 5th and the 6th, could we? Sunday the 5th and Monday the 6th. Alia, that's okay with the court, is it?
Yes, that would be fine.
That's okay with me. Mr. Wheater, what about you?
That's okay with us, my lord.
Okay, and Mr. Dwela probably doesn't make much difference to you, but let's make sure.
Yeah, correct. Doesn't make much difference.
Okay. Well, if we do that, then we can make those earlier dates of the 28th and 29th of October into, of November, into perhaps by the 30th of November and the 1st of December. That's the preceding Tuesday and Wednesday prior to the holiday on the Thursday. Does that seem okay, gentlemen?
It does, my lord.
Okay. All right. Well, I think that gives us our timetable. And may I repeat, it is going to be important to stick to that timetable. If there is any hiccup in it, in the sense that there's some disagreement between the parties, the best way to deal with it is to put it in a letter what the disagreement is, send it to the registry who can send it to me. Let's try and resolve things, and I can resolve it by email, or if necessary we can have a short hearing, but I hope that that's not necessary, so that we can hit that sort of hiccup, if there is one, on the head without any problem with the overall timetable. Mr. Wheater, I'm sure, is used to that sort of thing. Mr. Dwela, do you understand what I mean?
I do. Yes, Mr. Just.
Yes. All right. Well, in a second, I'll just ask if there's anything else either of you wants to raise. But Mr. Wheater, would you be good enough, please, to complete the proposed timetable that you had prepared with the dates and so on, and provide it to the registry so that there's a record there of what we've been through. Send a copy, of course, to Mr. Dwela, and the registry will use that to make the appropriate formal orders.
My lord, I will. Just one point of clarification. Can I just take you to paragraph 12 of the draft order?
Yep.
It's always because I'm always reticent to tell the court when it will do things. Are you satisfied with the timetable for the court determining objections to disclosure?
Yes, I'm happy to put that in, provided that the parties assist. In other words, if there is an objection, I get the letter which describes what the problem is, and I will give a decision.
My lord, I am hoping that any objections will be set out on a Redfern schedule for your lordship.
Yeah. Well, I hope that it won't arise. both parties should remember that it's often, even if you doubt something, doubt a relevance or something like that, disclose it. Doesn't matter. You don't spend costs on arguing about a thing like that. Get on with the job.
Indeed. I'm grateful, my lord.
All right. Well, now then, Mr. Dwela, is there anything else that you want to raise for discussion at this conference, or should we leave it to the timetable and hope that the next time we meet is at the trial?
Your Justice, just one thing. When will Damac provide us with the timetable?
With this document, with the
With
date?
this, yes. I didn't have the time to actually jot down all the dates. So when can we expect any official communications regarding that?
Well, I will circulate it pretty much immediately after this hearing once I've made those changes, and then the registry will send out the official order.
Thank you.
Yes, thank you very much. So anyway, but proceed in accordance with the timetable, Mr. Dwela, even before you get the official order, please. It's the timetable we're working to. All right.
Yeah.
Mr. Weeder, anything you want to raise?
Not from my side, my lord, no.
All right. Well, thank you both for the efficiency with which we've dealt with this. And Alia, thank you for helping us not make a mistake about the date. And I think we can now adjourn the hearing by logging out. Thank you.
Thank you, Your Justice. Thank you.